Rule number 59. Receivership. Section 1. Appointment of receiver.
Receivership is an auxiliary remedy, a mere incident of the suit to help achieve its purpose. During the pendency of an appeal, the appellate court may itself appoint a receiver subject to its control or allow the court of origin to appoint a receiver who shall be under its control. The receivership is aimed at the preservation of and the making secure of existing rights. By receivership, property, real or personal, which is subject to litigation, is placed in possession and control of a receiver appointed by court, who shall preserve it pending final determination of the title or right of possession over it. A writ may be issued first when it appears that the party applying for the appointment of a receiver has an interest in the property or fund which is the subject of the action or litigation, and that such property or fund is in danger of being lost, removed, or materially injured unless a receiver is appointed to guard or preserve it. Second, when it appears that the appointment of a receiver is the most convenient and feasible means of preserving, administering, or disposing of the property in litigation. It should be noted that the property or fund must be in litigation according to the allegations of the complaint, and the object of appointing a receiver is to secure and preserve the property or thing in controversy pending the litigation. Who is a receiver? It is an indifferent person between the parties to a cause, appointed by the court to receive and preserve the property or fund in litigation pending lite, when it does not seem reasonable to court that either party should hold it. He is also considered as an officer of court, exercising his function in the interest of neither plaintiff nor defendant, but for the common benefit of all parties in interest. He is wholly impartial and indifferent to all parties in interest. So, Rule 59 applies to all kinds of receivers: habilitation receivers, receivers of entities under management, ordinary receivers, receivers in liquidation, and for different kinds of situation. Who may appoint a receiver? Municipal courts, regional trial courts, Court of Appeals or any member thereof, Supreme Court or any member thereof. Also, SEC has jurisdiction over dissolution of corporations and appointment of receiver in relation thereto. Power to appoint a receiver. This power is not an absolute right. It depends upon the sound discretion of the court and is based on the circumstances of each particular case. It should be exercised with extreme caution and only under circumstances requiring summary relief or where the court is satisfied that an imminent danger of loss, lest the injury thereby caused be far greater than the injury sought to be averted. Again, the order appointing a receiver is interlocutory. An appeal from an order making such appointment can be interposed only after final judgment is rendered, so the proper remedy in such cases is certiorari. What are the requisites for the issuance of writ under Section 1, Paragraph 8? So first, the party applying for the appointment of a receiver should have an interest in the property which is the subject of an action, which is actual existing interest. Second, the subject property or fund must be in litigation according to the allegations of the complaint. And third, the purpose of appointing a receiver is to secure and preserve such property or fund pending in litigation. While the requisite for issuance of the writ under Section 1, Paragraph B is that the property or fund subject of the action is in danger of being lost, removed, or materially injured, necessitating its protection or preservation. If the action does not require such protection or preservation, the remedy is not receivership. Section 1, Paragraph C also provides that trial court has jurisdiction to appoint receiver after perfection of the appeal. So the trial court still has the power to hear and decide an application for the appointment of a receiver. In such case, the action may be regarded as yet pending for the purpose of an application for a receiver. The office of a receiver is manifestly to aid by preservation of property and making effective the court's decree. Limitation of the court in the appointment of receiver under Section 1, Paragraph B. So this section is couched in general terms and broad in scope. The court, in granting applications for receivership under this section, must be mindful of the basic principle that receivership may be granted only when circumstances so demand and when there is a clear showing of necessity for it in order to save plaintiff from grave and immediate loss or damage. Now, in cases of controversies involving business organizations and partnerships, a party may apply for the appointment of receiver when there is imminent danger of dissipation, loss, wastage, or destruction of assets or property, paralyzation of business operations, which may be prejudicial to the interests of minority stockholders, parties, or the general public.
Section 2. Bond on appointment of receiver.
Section 2 of Rule 59 simply requires the applicant to file a bond executed by the party against whom the application is presented. The amount of such bond shall be fixed by the court. The purpose of this bond is to guarantee the payment of all damages that the adverse party may sustain by reason of the appointment of such receiver in case the applicant has procured the same without sufficient cause. Take note that the filing of the applicant's bond is mandatory and is required at all times, and that the consent of the parties that there is sufficient cause to appoint a receiver is of no moment and will not justify an exception to this requisite.
Section 3. Denial of application or discharge of receiver.
The application for receivership may be denied or the receiver may be discharged in the following instances. First, when the adverse party files a bond executed to the applicant in an amount fixed by the court, to the effect that such party will pay the applicant all damages he may suffer by reason of acts, omissions, or other matters specified in the application as ground for such appointment. Second, if it is shown that the appointment of the receiver was obtained without sufficient cause. And third, when the applicant bond is found to be insufficient and a bond sufficient in an amount with sufficient sureties is not filed forthwith. It is not mandatory for the court to set aside the receivership if an offer to post a counter bond is filed. The word may is construed as permissive. Thus, the trial court has to consider the posting of the counter bond in addition to other reasons presented by the offeror why the receivership has to be set aside. And lastly, the receiver may be discharged if the defendant was not permitted to file a bond. In an action for foreclosure of mortgage wherein the plaintiff prayed for the appointment of a receiver on the ground that the mortgage properties were deteriorating and would not be sufficient to cover the mortgage debt, the defendant should be permitted to file a bond pursuant to the rules.
Section 4. Oath and bond of receiver. Before entering upon his duties, the receiver shall be sworn to perform them faithfully, and shall file a bond executed to such person and in such sum as the court may direct, to the effect that he will faithfully discharge his duties in the action or proceeding and obey orders of the court.
Under Section 4, we also distinguish between the bond filed by the applicant and the bond filed by the receiver. The former answers only for all damages that the adverse party may sustain in case the applicant shall have procured such appointment without sufficient cause, while the latter answers for damages that may have been suffered by failure of the receiver to discharge his duties faithfully or by failure to obey the orders of the court.
Service of copies of bonds. Effect of disapproval of same.
안녕하세요. Aira-eyo. Bangawayo. Hi, nice to meet you all. I'm with K-Minyo, a member of the K-pop 17, and he will help me today to report about the Section 5 receivership. So without further ado, are you now ready, K-Minyo? Medyo naghang ka dyan. So, Aja, can you tell me about the person filing a bond? Kim In-yo, can you tell me more about it?
Hello everyone. Kim MING you the rapper of the K-pop 17. Pod in Kiko. I will help Miss Eva Julikianan. So without further ado, the person filling a bond shall serve a copy thereof on each interested party, who may accept to its sufficiency of the surety or sureties thereon, sec. Rule 59. 타마디바, 셀러메인.
Tamang-tama, Kim In-yo, because the person filing a bond shall serve a copy thereof on each interested party, who may accept to its sufficiency or of the surety or sureties thereon. Now, Kim In-yo, can you give me more about the instances when appointment may be denied? Can you tell me more about it?
스타트나 BAAK요. OK 파라케이트 in instances when appointment may be denied. B. When the appointment sought or granted is without sufficient cause. sec. 3. 2. When the adverse party files a counterbond to answer for damages. 3. When the applicant's bond is insufficient. Rule 59. sec. 5. 4. When the receiver's bond is insufficient. 타포스나 타마디바 사랑해.
Saranghe, Kim In-yo, yes, because the instances when appointment may be denied, first, when the appointment sought or granted is without sufficient cause. Tama. Second, when the adverse party files a counter bond to answer for damages. Third, when the applicant's bond is insufficient. And the last one is that when the receiver's bond is insufficient. So,
Thank you everyone and I hope to see all. Thank you din RICO QICHO. Eva said that you are the most handsome din in the world. I can't wait to meet you and also the 3S and 3D civil procedure. 사랑해 din RICO QICHO. 사랑해. Goodbye for now. 마할 코카요. 마할 키타 din.
thank you everyone! Thank you, Kim In-yo!
Section 6. General powers of receiver. Subject to the control of the court in which the action or proceeding is pending, a receiver shall have the power to bring and defend, in such capacity, actions in his own name, to take and keep possession of the property in controversy, to receive rents, to collect debts due to himself as receiver, to the fund, property, estate, person, or corporation of which he is the receiver, to compound for and compromise the same, to make transfers, to pay outstanding debts, to divide the money and other property that shall remain among the persons legally entitled to receive the same, and generally to do such acts respecting the property as the court may authorize.
So having enumerated the general powers of a receiver, the question now is, are there any restrictions on what the receiver may do? First, court authority is needed to enter into a contract. A receiver has no power to enter into a contract without the approval of the court. Unauthorized contracts of a receiver are not binding on the court in charge of receivership, but are binding on the receiver's own contracts or personal obligations. Second, leave of court is required for an action to be filed by or against the receiver. The reason behind Section 6, which requires leave of court, is to forestall any undue interference with the receiver's performance of duties through improvident suits. Third, an action cannot be brought against a receiver based on his management of the receivership property without leave of the court which appointed him. It is the duty of the court to protect the possession of its receiver and to prevent all interference with him in the performance of his official function and duties. Fourth, authorization of court is not necessary in mortgage foreclosure suit when mortgage was constituted before the appointment of receiver. And lastly, all official acts and transactions of the receiver approved or ratified by the court shall render the receiver immune from any suit. Thank you and good evening.
Section 7. Liability for refusal or neglect to deliver property to receiver.
A person who refuses or neglects, upon reasonable demand, to deliver to the receiver property within his power or control, subject of or involved in the action or proceeding, or in case of disagreement, as determined and ordered by the court, may be liable for 1. Contempt, 2. The money or the value of the property and other things so refused or neglected to be surrendered, and lastly,
all damages that may have been sustained by the party or parties entitled to the property as a consequence of such refusal or neglect.
Section 8. Termination of receivership. Compensation of receiver.
When the necessity for a receiver no longer exists, the court shall determine that the necessity for a receiver no longer exists motu proprio or on motion of either party. After due notice to all interested parties and hearing, the court shall first determine the account of the receiver, second, direct the delivery of the funds and other property in his possession to the person adjudged to be entitled to receive them. Third, order the discharge of the receiver from further duty as such, and lastly, grant the receiver such reasonable compensation as the circumstances of the case warrant, to be taxed as cost against the defeated party or apportioned as the judge requires. When the services of a receiver who has been properly appointed terminate, his compensation is to be charged against the defense party, or the prevailing litigant may be made to share the expense as justice requires.
Section 9. Judgment to include recovery against sureties. The amount, if any, to be awarded to any party upon any bond filed in accordance with provisions of this rule shall be claimed, ascertained, and granted under the same procedure prescribed in Section 20 of Rule 57.
Section 9. It has the same procedure prescribed in Section 20 of Rule 57. Under Section 20 of Rule 57, a claim for damages on account of improper, irregular, or excessive attachment. When an application for damages may be made, one would be before trial. It may be made as of right. It may properly set up by way of counterclaim in the answer or in the supplemental answer if the attachment was made and damages were suffered after the filing of the original answer. Second, after trial but before the entry of the judgment, it may be made in the discretion of the court before the appeal is perfected, before the judgment becomes executory, and third, during the pendency of appeal if the judgment of the appellate court is favorable to the adverse party.
I am Attorney Ramon Saura, and I was appointed as receiver for the World War II Veterans Enterprises. During my term, I went to Japan upon the order of the court for the purpose of checking a purported undervaluation of goods shipped to the war vets. I was reimbursed by the court for the expenses I have incurred during the trip. However, aside from that, I have received no other fee or compensation despite having performed my duties as receiver for a continuous period of 3 years. The lower court has denied the motion to fix my compensation, and because of this, I have decided to resign from my post as receiver. Nonetheless, I am still asking this court to please reimburse me for my expenses. I have also incurred in securing the services of a legal counsel when I was receiver.
No, Attorney Saura, you cannot ask for reimbursement. The expenses you have incurred during your trip to Japan had already been reimbursed and settled in a previous case. As regards the additional claim for reimbursement, the court cannot reimburse you for securing the services of a legal counsel because this act was done without prior leave of court. As a lawyer, you should have known that it is inherent in the office of a receiver to not only act at all times with the diligence and prudence of a good father of a family, but also to not incur any obligation or expenditure without leave of court. Whatever amount you now seek in addition to the reimbursement already given would be improper. Therefore, we deny your motion.
Good evening, class. Let's start. Our topic for today is receivership under Rule 59 of the Rules of Civil Procedure. So tonight we will discuss the case of Tantano versus Espino, Cabo Verde. Now in this case, why should the application for receivership be denied? Anyone? Oh, Mr. Giant. Oh my gosh. How will I pay for these medications? Ting! I will apply for receivership.
Dominada's argument that she needs income for medical expenses is not enough. Financial need and like reasons are not among the grounds for granting receivership under Rule 59, Section 1.
Okay, now give me a second reason for the denial. Anyone?
Ma'am, I would like to volunteer po.
Okay, Jana.
There is no clear showing that the disputed properties are in danger of being lost or materially impaired, and that placing them under receivership is the most convenient and feasible means to preserve, administer, or dispose of them.
And now, a third reason. +5, third reason. Okay, Giant.
Ma'am, may mas magandang sagot ako dyan.
Okay.
O ito ha, ang Dominalda. Dominalda's daughter, Josephine, shall be appointed as administrator. Dominalda will be entitled to receive 1/2 of the net income that is derived from the uncontroverted properties, as well as Josephine shall provide for the medicine of her mother. So once again, Ma'am Dominalda ha, may net income ka na, meron pang mag-provide na medicine para sa'yo. Okay?
Dominalda is already bound to receive income and medicine under the TSA. I don't see any reason why Dominalda would suffer grave and immediate loss or damage if the property is not placed under receivership.
Now, there is a last reason here, the fourth one. So, what else? What else? Anyone? How about you, Jana?
Sorry ma'am, I can't recall na po.
Maybe Giant?
I don't feel any pressure right now. The petitioner, there was the one who's very oh, I'm so sorry, ma'am. My family, oh my god. Okay, I'm so sorry. I told you that I'm so confident. Wait. Sorry guys, because this was really my first receive ever. And I'm only 17 years old. I did not expect that I came from I came from the top 10. So I'm sorry, ma'am. I don't have anything.
Ayan, kasi you're not reading the full text. Now, the correct answer is, the defendants in the civil case were already registered owners of the property. Their case is not considered extreme enough to show the necessity of appointment of receivership to save the plaintiff from grave or irremediable loss or damage.
After obtaining a loan from Citibank, private respondent Douglas Anama executed a promissory note to pay the plaintiff back. In order to secure payment of the loan, Douglas also constituted a chattel mortgage in favor of the petitioner on various machinery and equipment under certain terms and conditions.
Hello? Sino to?
Is this Douglas Anama? This is Citibank.
Kayo ulit? Ano na naman ba?
Good day po, sir. We are calling once again to remind you of your promissory note. We have repeatedly remind you po. Wala na kaming po choice kundi mag-file ng complaint against you for the collection of the unpaid balance of your promissory note, as well as the delivery and the possession of the chattels. I hope you understand po. For failure and refusal of the private respondent to pay, despite repeated demands, petitioner filed a verified complaint against Douglas for the collection of his unpaid balance on the said promissory note for the delivery and possession of the chattels covered by the chattel mortgage preparatory to the foreclosure thereof.
Sige, hintayin niyo ang answer ko. Kasama yun with counterclaim.
The Court of Appeals ruled that the requirements, particularly the filing or posting of a bond and the taking of an oath in Section 5, Rule 59 on receivership were not complied with by the petitioner. However, the old rules of court, which was in effect at the time this case was still at trial stage, a bond for the appointment of a receiver was not generally required of the applicant, except when the application was made ex parte. The Court of Appeals was right in finding a defect in such assumption of receivership, in that the requirement of taking an oath has not been complied with.
Dear Charo, itago mo na lamang ako sa pangalang Nila. Ito ay hinggil sa aking kaso tungkol sa receivership. Ang alitan sa petisyon sa ilalim ng Rule 45 ay ang legalidad ng resolusyon ng Camiguin Regional Trial Court na naglagay sa ari-arian ni Severino Reyes sa ilalim ng receivership. Hindi sumang-ayon ang Court of Appeals sa desisyon na iyon, Charo, at ipinabalik ang RTC Directive sa appointment ng receiver na nag-udyok sa akin at kay Julio Rivares na maghain ng petisyon para kumbinsihin ang korte na ibalik ang receivership.
Oo. Tsawa ko kanina, nagpung din ako. Ikaw, di ka pa nagbayad sa akin, ha? Sandali, may tumatawag na sa akin, ha? Sandali. Oh, hello, Vivares, bakit? Ano? Damn it! Hindi ako papayag na magulangan dito. Aba, hindi pwedeng mangyari na ang property na yan ay hindi mapunta sa akin. Baka nakakalimutan nila I am the lawful heir of Torquato and it is my right to contest what is mine. Ay hindi. Ang kay Torquato ay kay Torquato at kailangan nilang malaman yan. Gawa mo na paraan yan. Diyos ko ba naman, kahit dito sa Majong nadadayan ako, pati naman sa property. Buhay to eh. Yung sibo na print na ba? O sige, sandali, may kausap lang ako. Huwag kayo maingay dyan. Wait, may signaling. Sandali lang at hindi ko kayo marinig. Ikalma mo muna. Ang alta presyon. Huwag kang mag-alala. As the designated executor of Torquato's last will and testament, just leave it to me. And the property will be yours. But dude, chill lang. For your information, all properties of Severino was already transferred prior to his death. At ito ang ebidensya na si Torquato ay matagal nang na-convey ang several lots sa estate of Severino. At kung makikita mo, ito ay nakabase sa oral partition between sa magkakapatid. Kaya pwede ba? Don't me, don't us. Madude. Wait lang ha. Hayalay na ako dyan ha. O mahipong pa ako. Huwag mo akong Sandali nga lang. Asan na yung shades ko? Ba't nawawala yung shades ko? Dito pala sa Huwag mo akong pinagluloko. Don't me ha. Hindi ako papayag. Kahit saan man tayo umabot, ipaglalaban ko ito.
Ang hukuman ay nagtalaga ng 3 commissioner upang pagsamasamahin ng mga ari-arian na pinagkatalunan at ang mga ito ay nilagyan ng annotation ng may abisong lease pending. Nabigo ang mga petitioner na magbigay ng malinaw, kapanipaniwala at matibay na ebidensya upang ipakita ang di umano'y pandaraya sa paglipat ng titulo at ang pag-antedate nito. Ang mga ito ay napetsahan bago ang pagkamatay ni Torquato at hindi nangangahulugan, paglipat ng titulo ay may kasamang pandaraya.
Hoy, LBLC! Here's a writ of sequestration over your properties. Sabido shares of your stock are illegally acquired wealth. What? I don't know what you're talking about. I'm filing a complaint for a conveyance, reversion, accounting, restitution, and damages against Sabido. Yeah, no. I'm filing a motion to lift the writs of sequestration.
Sabido approved.
removed! Wait! Kindly reconsider!
No, I don't think I will.
Hey RTC, I'm gonna file for a complaint for sum of money against LBLC. Also, I'm praying for a writ of preliminary attachment.
Sure. Writ granted.
Hey! RTC has no jurisdiction to order the attachment of the sequestered properties. Those assets were placed under custodial aids of the PCGG pending the final determination of the Sandigan Bayan that they were actually ill-gotten. My original complaint was for a sum of money because LBLC owes me. Besides, the attachment order was issued after the Sandigan Bayan lifted the writ of sequestration against LBLC. GS. Thank you very much.
Petition granted. For the first issue, yes, the RTC has jurisdiction following Section 19 of VP 123 as amended by RA 7961. Additionally, his case concerns receivables of the private respondent arising out of a legitimate business contract to supply goods and services in favor of LBLC. PCGG is not an owner but a conservator. It can exercise only powers of administration over property sequestered, frozen, or provisionally taken over. Even assorted provisional remedies should entail the least possible interference with business operations or activities, so that, in the event that the accusation that the business enterprise is ill-gotten be not proven, it may be returned to its rightful owner as far as possible in the same condition as it was at the time of the sequestration. On the second issue, the answer is no. The disputed properties of LBLC were already under custodial ledges by virtue of a writ of valid sequestration issued by the PCGG. When respondent judge issued a sealed writ of attachment in favor of private respondent Hong Ming Kok. At that time, the writ of sequestration issued by PCGG against LBLC was subsisting, and said writ could not be interfered with by the RTC of Lianga because the PCGG is a coordinate and co-equal body. The PCGG had acquired by operation of law the right of redemption over the property until the final determination of the case or until its dissolution. When the Sandigan Bayan ordered that the writ be lifted, PCGG filed a special civil action for certiorari to contest that order. The Supreme Court ruled in favor of PCGG when it granted the latter's petition to declare the lifting of the writ of sequestration by the Sandigan Bayan null and void. In the same on-bank resolution, the court explained that special adjective tools or devices were provided by the revolutionary government for the recovery of that ill-gotten wealth. These took the form of provisional remedies akin to preliminary attachment under Rule 57, writ of seizure of personality, Rule 60, and receivership, Rule 59. Sequestration is defined as the process which may be employed as a conservatory writ whenever the right of the property is involved. To preserve pending litigation specific property subject to conflicting claims of ownership or liens and privileges. Sequestration, freeze order, and provisional takeover are ancillary remedies in prosecuting the ill-gotten wealth of the previous Marcos regime. Sequestration, freezing, and provisional takeover are akin to the provisional remedy of preliminary attachment or receivership. Such proceeding is in effect a finding that the property attached is an indebted thing and results in its virtual condemnation to pay for the owner's debt. By an order of attachment, a sheriff seizes property for defendant in a civil suit so that it may stand as security for the satisfaction of any judgment that may be obtained, and not disposed of or dissipated or lost intentionally or otherwise pending the action. The attachment lien shall continue after the rendition of the judgment, and it must continue until the debt is paid, or sale is under execution issued in the judgment, or until the judgment is satisfied or the statement discharged or vacated in some manner provided by law. When a writ of attachment has been levied on real property or any interest therein belonging to a judgment debtor, the levy creates a lien which nothing can destroy but its dissolution. This well-settled rule is likewise applicable to a writ of sequestration. Attachment is the nature of a proceeding in rem. It is against a particular property of a debtor. The attaching creditor thereby acquires a specific lien upon the attached property, which ripens into a judgment against the rest when the order of sale is made. Wherefore, the instant petition is partially granted. The default order issued by the public respondent dated March 19, 1993 is affirmed, but should be held in abeyance until the sequestration case involving LBLC before the Sandigan Bayan is determined. The order of attachment issued by the public respondent is declared null and void. No pronouncements as to cost. So ordered.